Germany was 5 years old when she was shot. This is a picture of her 5th birthday cake.
That second round of heroin that ended up killing Katie Golden. She passed away because of the drug they had bought from this defendant.
Memory issues. I'll go inner voice on that whole thing. Run people into a telephone pole and things go bump in the night, you might have some memory issues, huh?
In January 2020, Kaliek Goodford carried out a deadly shooting at the home of Jimmy and Shatavia Chrysantos in the town of Newburgh, New York. Believing that Jimmy was involved in an affair with his girlfriend, Goodford sent threatening messages before storming the Chrysantos residence and fatally shot Jimmy, Shatavia, and Shatavia's son, Giovanni. Their younger son was also shot but survived, while their daughter witnessed the horrific crime. After the attack, Goodford fled in a cab with a woman. The cab driver later reported hearing shots and noticing the woman silently mouthing, "Help me," prompting the driver to alert authorities. Goodford attempted to destroy evidence by burning his clothes and throwing the murder weapon into the Hudson River, where it was later recovered by divers. The case was delayed due to the COVID-19 pandemic and evaluations of Goodford's mental competency. Nevertheless, in January 2025, a jury found him guilty on all charges, including 3 counts of first-degree murder and attempted murder.
And I do pray that God helps him and he repents of what he did. I need to forgive him in my heart for me to be able to move on. Yes, it does hurt me a lot because he did hurt my father and my brother's father's parents.
In March 2025, during the sentencing, Shatavia's daughter, Iriana Santos, addressed the court in a moving victim impact statement, expressing her desire to forgive in order to heal.
I'm not the one that committed this crime. Yeah.
Goodford continues to deny the charges and plans to appeal the verdict.
The defendant is hereby sentenced to life without parole.
Judge Craig Stephen Brown stated that the evidence against Goodford was overwhelming. He emphasized the severity and senselessness of the crime and sentenced Goodford to life in prison without the possibility of parole. On the night of March 9, 2025, Kyle Hill, 33, argued with his ex-girlfriend, who then left in a friend's Honda Accord. Believing he had found her vehicle, Hill followed it aggressively, thinking she was inside. However, the car was actually being driven by Norbelis Figueiredo Campos and his girlfriend, Arisleni Blanco Medina, who were simply on their way to Walmart. Hill forced their car off the road, causing it to crash. The crash resulted in Blanco Medina's death and left Figueiredo Campos critically injured. Hill's SUV also lost control, crashing into a tree. Hill's blood alcohol level was over twice the legal limit, and he was on probation for a prior battery charge.
You mention their name to anybody and they're like, oh yeah, what a great person. They were loved by all. She wishes that the person who caused this and that her Norbelis and Arislenis gets justice.
Initially facing charges of DUI manslaughter and vehicular homicide, the charges against Hill were later upgraded to first-degree murder and attempted murder after further investigation.
Memory issues. I'll go inner voice on that whole thing. Run people into a telephone pole and things go bump in the night, you might have some memory issues, huh?
Hill appeared in court in a wheelchair, stating he was unsure if he could afford an attorney.
How much money you got in the bank?
He claimed to have no memory of the incident.
Memory issues. I'll go inner voice on that whole thing. Run people into a telephone pole and things go bump in the night, you might have some memory issues, huh?
He is currently held without bond, facing several charges, including a violation of his probation from a previous felony battery conviction. On the evening of March 17, 2025, retired Polk County Sheriff Sergeant Dan Cooley, 69, was tragically killed while trying to do the right thing. He had pulled over on East Van Fleet Drive in Bartow, Florida, near a Walmart, to remove a large plastic tote that had fallen from his vehicle and was obstructing the road. With his hazard lights flashing, Cooley stepped out of his car to clear the lane. As he attempted to retrieve the item, he was struck by a westbound 2008 Jaguar S-Type driven by 50-year-old Aaron Wells of Winter Haven. Cooley was rushed to the hospital, but later died from his injuries.
He didn't start the evening by intending to kill someone, but he did. And do you know why he did? He was drinking.
According to the Polk County Sheriff's Office, Wells showed clear signs of impairment at the scene. He admitted to drinking a few beers before driving and registered blood alcohol levels of 0.092 and 0.0105 on 2 separate breath tests, both above Florida's legal limit of 0.08.
Appointed to represent you, or are you going to hire a private attorney?
I'm going to hire private.
Wells' daughter was also in the vehicle at the time. Wells was arrested and charged with DUI manslaughter and negligent child abuse.
Sergeant Cooley, who had retired in 2007, was simply trying to go back and do what a responsible person does. I dropped something in the road. I want to rapidly get it out of the road. He was all in. Everybody knew him. He loved to talk. He was the guy who visioned for the future. He always had new ideas and better ideas, how things could be done, and he wanted to make sure everybody knew them.
Sheriff Grady Judd expressed heartbreak and frustration, stating that Cooley, a man known for his integrity and service, lost his life in a completely avoidable tragedy caused by one man's selfish decision to drink and drive. In July 2020, 29-year-old Joshua Sutphin was found dead from a heroin and fentanyl overdose inside his home in Riverview, Florida. Investigators discovered drug baggies marked with red dice at the scene. The same day, Joseph Stilitano was pulled over while driving Sutphin's car and was found with matching baggies. A review of text messages and financial records revealed that Stilitano had been in contact with Sutphin on the day of his death, arranging the drug sale.
There is evidence of other drug transactions prior to the date of the overdose.
Authorities arrested Stilitano in June 2021 and charged him with first-degree murder under Florida's drug-induced homicide law.
Did unlawfully and feloniously kill a human being, to wit, Joshua Sutphin, which resulted from the unlawful distribution by Joseph Michael Stilitano Jr.
He rejected a 25-year plea deal and opted for trial. In May 2023, a jury found him guilty of manslaughter, determining that his actions showed clear negligence. The following month, he was sentenced to 12 years in prison. In April 2017, Katie Golden, a senior at Plant High School in Tampa, tragically died from a heroin overdose at her boyfriend Titan Goodson's home. Initially, the death was ruled accidental. However, after further investigation, it was determined that Goodson had been involved in procuring the heroin, leading to his arrest. Goodson was charged with manslaughter and tampering with evidence.
It was that second round of heroin that they used later that evening that ended up killing Katie Golden. She passed away because of the heroin that they had bought from this defendant.
Hello.
Hi, can you hear us all?
He ultimately pleaded guilty and served a year in jail, agreeing to testify against Garland Ryan Layton, the drug dealer believed to have supplied the fatal dose. In March 2020, Layton was arrested on a first-degree murder charge under Florida's death by distribution law, which allows for murder charges when drug distribution directly leads to a death. Layton's trial was set to begin in August 2022, but before it could start, he accepted a plea deal. Layton pleaded guilty to manslaughter, resulting in a 10-year prison sentence followed by 7 years of probation. He was also designated as a habitual offender. Katie Golden's parents expressed mixed emotions upon hearing the plea deal. While it brought some closure, they still struggled with the loss of their daughter. Yvonne Rivera Ramos was known in her Tampa, Florida community as the Avon Lady, selling beauty products door to door. But behind her friendly image, she had a secret side business selling illegal prescription pills. On July 28, 2016, she arranged a deal at the Rivergate Apartments, unaware it was a setup. 2 men, including Jose Colon Soto, planned to rob her. When Rivera Ramos sensed the danger and tried to flee, one of the men shot her. She managed to drive away, but later died from her injuries in a nearby parking lot.
Discharged a firearm, striking Ms. Ramis.
How do you wish to plead to that charge of second-degree murder?
Guilty.
5 years later, Colon Soto took a plea deal, pleading guilty to second-degree murder.
I hope every time you close your eyes, the image of my mother you helped set up and haunts you. I hope the guilt of your actions overtakes you.
Y voy a seguir peleando por mi familia. That the mind can change and I'm going to continue to fight for my family.
Pero esto nunca debió pasar.
But this should have never happened.
During the hearing, Rivera Ramos's daughter told Colin Soto she hoped the memory of her mother would haunt him, while her sister described the family's deep pain.
As far as Mr. Colin Soto, your plea agreement you got in this case was a gift you didn't deserve, and I'll leave it at that. This was for nothing. Fingerprint him and get him out of here.
The judge criticized the leniency of the deal, calling it a gift Colin Soto didn't deserve, as it allowed him to avoid a harsher sentence. Under the plea agreement, he received 15 years in prison, followed by 5 years of probation, a resolution that left the victim's family heartbroken and dissatisfied. In June 2020, 28-year-old Chegofatso Pule, who was 8 months pregnant, disappeared after visiting her boyfriend in Tuthuco Shoba at his apartment in Florida, Johannesburg. CCTV footage later showed her entering a gray Jeep, believing it was an e-hailing ride arranged by Shoba. Days later, her lifeless body was discovered. Rudeport. She had been shot before being staged to look like she had killed herself. The man who committed the murder, Muzikeisi Malafane, confessed shortly after his arrest. He revealed that Shoba had hired him to carry out the killing for 70,000 rand, allegedly to avoid his wife discovering the affair and the pregnancy. In exchange for turning state witness, Malafane received a 20-year sentence. Shoba was arrested in February 2021 and charged with murder, conspiracy to commit murder, and defeating the ends of justice.
I just ask you, Mr. Malafane, do you know where he is?
Yes.
Where is he?
Medium B. They can't meet because these two prisons, they are apart.
After a detailed trial where WhatsApp messages and call logs were presented as key evidence, the court found Shoba guilty of premeditated murder in March 2022. He was sentenced to life imprisonment in July 2022. President Cyril Ramaphosa publicly welcomed the verdict, underscoring the importance of justice in cases of gender-based violence. In September 2024, Patrick Hayes was fatally shot in a road rage incident near the Ross Creek entrance of Jordanelle State Park. The shooting occurred after Hayes approached Greg Kyle DeBoer's Jeep Gladiator, resulting in a single shot. Hayes' body was found the next day, and an autopsy confirmed his cause of death as being shot. Investigation led authorities to DeBoer, whose vehicle was traced to the scene using cell tower data. They later discovered that DeBoer owned a firearm matching the bullet recovered from Hayes. Although DeBoer admitted to the shooting, he claimed it was an act of self-defense, citing Utah's Stand Your Ground law. DeBoer was arrested on December 24, 2024, and charged with obstruction of justice after allegedly attempting to cover up the crime by burying the weapon. Despite his admission, no murder charges were filed due to insufficient evidence to disprove his self-defense claim. The obstruction charge carries a potential 15-year sentence. In court, DeBoer was granted bail with conditions, including wearing a GPS ankle monitor.
It's just so unfair to me. And then the fact that he wasn't arrested until Christmas Eve, or the day before Christmas Eve, and he was in jail for 3 nights. And Patrick's gone. Patrick's gone. I would love it if we could find more evidence to go with a harsher sentence, or at least a harsher charge, and definitely a harsher sentence.
Patrick Hayes' fiancée expressed their disappointment over the lack of a murder charge and filed a wrongful death lawsuit against DeBoer, hoping to hold him accountable for what they believe was an unjustified killing. In September 2021, Frankie Pina was riding his bicycle along Shell Point Road East and Interchange Street in Ruskin, Florida, when he was struck and by a pickup truck. The driver, later identified as Amber Zipperer, fled the scene, leaving Pina to die. Investigators eventually matched the damage on Zipperer's truck to the impact marks on Pina's bicycle, confirming her involvement in the hit and run. Zipperer, a repeat offender with 11 prior felony convictions, was brought to trial where her ongoing drug use became apparent, even during the court proceedings. Tampa Judge Michelle Cisco openly criticized her behavior, noting she had used drugs during the entire trial, including on the day the jury returned its guilty verdict. A psychologist explained her behavior.
Tends to seek drugs to feel better in the moment, and then that rekindles the addiction, and she's back to, of course, feeling worse rather than better.
Though her prior record could have landed her in prison earlier, avoiding capture at the scene likely spared her from a DUI manslaughter charge.
But the fact that you were not caught at the scene meant that I suspect you avoided a DUI manslaughter charge.
In March 2024, she was sentenced to 15 years in prison for leaving the scene of a crash involving death, followed by another 15 years of probation. The judge made it clear this was not just about justice for Pina, but also a long overdue reckoning for Zipperer's reckless and destructive lifestyle. In May 2023, Robbie Robinson Jr. brutally attacked Brenda Scott, his father's fiancée, at their Fairfield Township home. After a violent assault that left Scott injured in a desperate attempt to escape, she jumped from a 3-story window. Severely burned, Scott was rushed to the hospital, where she fought for her life for 31 days, but ultimately passed away from her injuries in June. Robinson was arrested and initially charged with aggravated arson and assault, later upgraded to aggravated murder after her death. Robinson's trial began in early 2025, where prosecutors presented damning evidence, including DNA and accelerants linking him to the crime. The defense was unable to prove his claims of a prior relationship with Scott, which were dismissed by the judge. In February 2025, the jury convicted him.
Watching her suffer every day is something I will never, ever get out of my mind. This effect has left me and my family in tears, and we will forever have a hole in our heart without her.
Judge, I will say to you that I will never forgive the defendant for what he did to my mother. There is nothing she could have done to deserve this. And what the defendant did is unforgivable and evil. And evil needs to be purged.
During sentencing, the victim's family delivered emotional statements, with Brenda's son calling the act unforgivable.
I cannot imagine jumping out that window. Her skin falling off, her teeth busted, her jaw hanging open. And yet she's jumping 3 stories and then responding to emergency workers. It's very sad.
The judge imposed the maximum sentence, life in prison without the possibility of parole, for the brutal murder, making it clear that Robinson's actions would not go unpunished. In June 2021, Xavier Davis was hired by Alexis Williams to murder the family of her ex-girlfriend, Danyavia Lagway, in southwest Houston. Davis and Lagway, her partner Gregory Carhe, and their daughter Harmony. The couple's other daughter survived by playing dead after being shot and later called for help while protecting her brother. After the killings, Davis stole a vehicle and set it on fire using matches purchased with money taken from the victims, but left behind a phone that led police directly to him.
Takes a $1 bill, he puts the rest of the cash in his pocket, and he hands that to the clerk. He's now bought his matches. The matches that are going to show up at that field in Pearland, next to the car that he stole so he could drive it to the Toro Place Apartments.
He was arrested shortly after and charged with 3 counts of capital murder and aggravated robbery.
You still wish to proceed in pleading guilty to this jury? Yes, sir. All right.
In 2025, just before his trial was set to begin, Davis pleaded guilty to capital murder. While the jury no longer had to decide his guilt, they were responsible for determining his sentence. The prosecution presented evidence of Davis's extensive criminal history and the brutal nature of the killings, while the defense argued that Davis's troubled upbringing, including abuse, played a role in his actions. Despite these arguments, the jury sentenced him to death, and prosecutors began pursuing charges against Alexis Williams, who allegedly orchestrated the murders due to her recent breakup with Lagway. Williams has pleaded not guilty, and her trial is scheduled for later this year. In May 2024, Victoria Goodwin, wife of Ghost Adventures star Aaron Goodwin, began corresponding with Grant Amato, a convicted murderer serving life for the 2019 killings of his family. Their relationship grew over time, with Victoria allegedly expressing love for Amato and even discussing plans to have her husband killed. She shared Aaron's filming details and locations, including a hotel in Barstow, California, and reportedly set aside $11,515 $1,000 for the murder, with $2,500 as an upfront payment. The plot was uncovered when authorities found incriminating text messages after a corrections officer confiscated a banned cell phone from Amato. Victoria was arrested on March 6, 2025 in Las Vegas on charges of conspiracy and solicitation to commit murder. Despite initially denying the charges and claiming the plans were only fantasies, the evidence led to her arrest. Shocked by the revelation, Aaron filed for divorce shortly after, citing irreconcilable differences. Victoria later pleaded guilty to conspiracy to commit murder on April 12, 2025, and is facing a sentence of 2 to 10 years in prison. Her next court appearance is scheduled for April 8, 2025. Kimberly Sullivan, a 56-year-old woman from Waterbury, Connecticut, is accused of imprisoning her stepson for over 2 decades. The victim, now 32, was rescued on February 17, 2025, weighing just 68 pounds. He had been confined to a room for 2 decades, enduring severe neglect, malnutrition, and isolation. His only contact with the outside world was limited to short tasks, such as letting the family dog outside. Desperate for freedom, he set a fire in his room in an attempt to attract attention. After being rescued, he was treated for smoke inhalation and diagnosed with PTSD and depression. Authorities described the abuse as the worst they have ever encountered. The victim's biological mother and half-sister were unaware of the abuse, expressing shock when they learned of the captivity.
I understand the whole world has jumped on those allegations and has already convicted my client. But the good thing about America is that's not how we work. She's presumed innocent until proven otherwise.
The 2 daughters also knew that he was there. They didn't say anything. They're complicit. Even the daughter's boyfriend that knew he was there. They all need to be charged.
Sullivan, who was arrested and charged with assault, kidnapping, unlawful restraint, and cruelty, denied the allegations, blaming her now deceased husband for the abuse. She was released on a $300,000 bond and faces a court appearance on April 22, 2025. The investigation continues as authorities work to uncover more details of the case. In mid-March 2025, the quiet city of Toledo, Ohio, was shaken by the disappearance of Keimani Lategue. The search for her ended in heartbreak when her lifeless body was discovered in an abandoned house on Miami Street. Investigators quickly identified a suspect, her own father, 44-year-old Darnell Jones, also known as Darnell Ogletree. Authorities began piecing together the events that led to her death. According to court documents, Jones forcibly removed Keimani from a home without the guardian's consent. Surveillance footage, telecommunication records, and witness statements helped investigators trace his movements. Eventually, Jones confessed to dragging his daughter to the vacant property, where he admitted to killing her. As law enforcement tracked him down, Jones fled to Columbus. There, on March 24, 2025, he was confronted by police officers. According to body cam footage and reports, he attempted to at the officers. In response, police opened fire, injuring him. He was hospitalized and, after recovering, transferred to the Lucas County Jail. Following his arrest, Jones was formally charged with aggravated murder, kidnapping, and gross abuse of a corpse.
All right, so the indictment has a case number on it, has your name on it, and it has some operative dates. This indictment, Mr. Jones, contains in it 15 different counts. A count is simply a charge you violate the. Let's start with the first one here. You've got count 1, aggravated murder, UF means unclassified felony with specifications. And it alleges that you did purposely and with prior calculation and design cause the death of Keimani Lategue in violation of those code sections, making it aggravated murder. Now you're going to see beneath that felony murder specification, which alleges that you committed, attempted to commit, or were fleeing immediately after committing or attempting to commit rape, and either the offender, you, were the principal offender in the commission of the aggravated murder, or if not the principal offender, you committed the aggravated murder with prior calculation and design. The specification under that also says felony murder. It's the same as the one I just read with the replacement. Instead of rape, it says kidnapping. And the third felony murder specification replaces rape or kidnapping with aggravated murder. Otherwise, those 3 specifications are essentially the same. You'll see on the next page that there is also a murder to escape specification, which reads that the offense was committed for the purpose of escaping detection, apprehension, trial, or punishment for another offense committed by you, to wit, rape, kidnapping, and/or aggravated burglary. Although that is what's called a sexual motivation specification, and it says that you committed the offense with a sexual motivation. And finally, it says sexually violent predator specification, saying that you are a sexually violent predator. Count 2 says all of the same things, essentially, other than it alleges that you did purposely cause the death of Kimani Lateef while committing or attempting to commit, or while fleeing immediately after committing or attempting to commit the offense of rape, aggravated murder, and unclassified felony. You'll see the same essential specifications: felony murder times 3, the murder to escape specification, and the other 2 specifications that were attached to count 1. I won't read those again for you, since your attorney rather is waived reading. I'm just going to go on to count 3, which is another aggravated murder charge, alleging you purposely caused the death of Kimani Lateef while committing or attempting to commit kidnapping. You'll see the same specifications in count 3 as you saw in counts 1 and count 2, with the names of the offenses changed where appropriate. And then there's count 4, which is the last aggravated murder charge against you. It reads similarly to the ones I just read. Okay. We'll move down to count 5. Count 5 is different. It's rape, a felony of the first degree with specifications, which alleges that you did engage in sexual conduct with Kimani Lateef when you purposely compelled her to submit by force or threat of force, constituting rape, a felony of the first degree. That charge has a sexually violent predator specification, as you can see below. Count 6 is similar. It alleges it's a count of rape with a specification. It alleges that you did engage in sexual conduct with Kimani Lateef while you purposely compelled her to submit by force or threat of force. Again, rape, a felony of the first degree, and it's got that same violent predator specification. Count 7, there it is on the screen, is a count of kidnapping. It's a felony of the first degree with specifications. Now that alleges that you did, by force, threat, or deception, remove Kimani Lateef from the place where she was found or restrain her liberty for the purpose of engaging in sexual activity with Kimani Lateef against her will, in violation of the law constituting the offense of kidnapping. Furthermore, the victim of the offense is alleged to have been under 18 years of age. That kidnapping charge carries with it both the sexual motivation and sexually violent predator specifications. Count 8 is also a kidnapping charge, alleging that you did, by force, threat, or deception, remove Kimani Lateef from the place where she was found or restrain her liberty for the purpose of facilitating the commission of or flight thereafter, also constituting the charge of kidnapping, a felony of the first degree that has the sexual motivation and violent predator specifications attached to it. And you'll see in count 9, that's the third kidnapping charge, alleging that you did, by force, threat, or deception, remove Kimani Lateef from the place where she was found or restrained her liberty for the purpose of terrorizing or inflicting serious physical harm on Kimani Lateef, or another violation of the revised code. Also kidnapping, a felony of the first degree with the same 2 specifications as the other 2 kidnapping charges. When we get down to count 10, it's now aggravated burglary, a felony of the first degree. Now that alleges that you did, by force, stealth, or deception, trespass in an occupied structure or in a separately secured or separately occupied portion of an occupied structure when Kimani Lateef, a person other than the accomplice, was present with the purpose to commit in the structure or in the separately secured or separately occupied portion of the structure any criminal offense, to wit, rape. and he inflicted or attempted or threatened to inflict physical harm on Kimani Lateef, constituting the crime of aggravated burglary, felony of the first degree. Counts 11 and count 12 are both endangering children. They're a little bit different, so I'll describe each one to you. The first count, that is count 11, of endangering children, alleges that you did abuse Kimani Lateef, a child under 18 years of age with his birthday provided, constituting endangering children with a furthermore clause that the violation resulted in serious physical harm to Kimani Lateef. And the other endangering children charge, felony of the second degree, count 12 of the indictment, alleges that you did torture or cruelly abuse Kimani Lateef, a child under 18, constituting endangering children, and that the violation resulted in serious physical harm to her.
During his arraignment, which took place in April, bond was set at $4 million, with strict conditions including no contact with minors or the victim's family, and the surrender of any passports.
The court's going to set bond on the murder at $2 million, no 10%. It's going to be $1 million on the felonious, $1 million on the abduction, no 10%. No contact with the alleged victim's family, no contact with any minor children, electronic monitoring on the murder if he posts, and defendants to surrender any passport.
On April 30th, 2025, Jones appeared in court and pleaded not guilty to all charges.
To the charge of aggravated murder on behalf of Mr. Jones, we offer a plea of not guilty. To the 3 felony murder specifications, the 29-2904A7 specifications, we offer pleas of not guilty. To the murder to escape specification, we offer a plea of not guilty. To the sexual motivation specification, we offer a plea of not guilty, as well as a plea of not guilty to the sexually violent predator specification. Likewise, for count 2, to the substantive count of aggravated murder, we offer a plea of not guilty. To the 3 felony murder specifications attached to that count, we offer a plea of not guilty. To the murder to escape specification, it's a plea of not guilty. Sexual motivation specification, we offer a plea of not guilty, and a plea of not guilty to the sexually violent predator specification. With respect to the substantive count charged in count 3, the aggravated murder, we offer a plea of not guilty. To the 3 felony murder specifications attendant to count 3, we offer a plea of not guilty. To the murder to escape specification, we offer a plea of not guilty, as well as a plea of not guilty for the motivation specification and the sexually violent predator specification. For count 4, it's the same process. To the substantive count, not guilty. To the 3 felony murder specifications, not guilty. Murder to escape specification, not guilty. Sexual motivation specification, not guilty. And the sexually violent predator specification, not guilty. Because those first 4 counts are capital offenses, I believe it's appropriate to enter a plea not only to the substantive count, but to each specification. Beginning with count 5, we don't have a capital charge. So what we're going to do is offer a plea of not guilty to count 5 and the attendant specifications. As to count 6, we're going to offer a plea of not guilty to the count and the attendant specification. With respect to count 7, we offer a plea of not guilty to the substantive count and to the 2 attached specifications.
The courtroom was heavily secured, with 17 deputies present due to the high profile and emotional nature of the case. Because he could face the death penalty if convicted, 2 attorneys certified to handle capital cases were appointed to represent him. He remains in custody at the Lucas County Jail. His next court appearance is scheduled for May 23, 2025. On a cold January day in 2014, tragedy struck a family on Cleveland's west side. Jermani Brooks was sitting in a parked SUV with her mother, Noni Brooks, and her 2 siblings. They were near their home on Crossburn Avenue when a man approached the vehicle and suddenly opened fire. 1 bullet struck Jermani, killing her instantly. Noni was also shot but survived. The other two siblings of Germani in the car were physically unharmed. Police quickly arrested the 32-year-old Jeffrey Gurkovich. Investigators discovered that the attack was not random. Gurkovich had reportedly come to the area looking for Noni's boyfriend, who had been in a dispute with Gurkovich's girlfriend earlier that day. Instead of confronting the man directly, Gurkovich fired into a car filled with innocent people. Charged with aggravated murder, felonious assault, and other related crimes, Gurkovich appeared in court for his arraignment. The judge set his bond at $5 million due to the severity of the charges and his prior criminal history. In November 2014, Gurkovich chose to plead guilty to murder and 2 counts of felonious assault. During the emotional sentencing hearing in December 2014, Noni Brooks shared pictures and memories of her daughter.
I'm Noni Brooks, the mother of Germani Brooks. We made poster boards with pictures of Germani. We have a lot of pictures of her. This first picture of her was at her daycare. She was about 2 years old, and as you can see, she was, the fashionista, like her teacher said. She loved taking pictures. She loved dressing up. This is her picture with, since Germani has been gone, I made this picture with both of her brothers on the end and her in the middle, because that's the way they came. Cameron first, and then Germani, and then the baby, Quentin Jr. And I look at this picture and I tell them so that they can know that she's still with them, that she's still there in the middle of both of them. And this picture is, of course, Germani laid to rest. She was, we dressed her up so pretty with her tiara and her dress we found to match her baby doll, because she loved baby dolls and dressing up and stuff. So her dress that she was laid to rest in and her baby doll door, because she loved it, door. They dressed like twins. And this sign above her casket, it says, "The princess sleeps here." I bought this for her and hung it on her room door. And she had that, on her room door. She was so proud of this sign, because when I read it to her, she was just like, "Oh, like, the princess sleeps here." So I made sure that I put this on her casket, because she's sleeping. This is where she sleeps now. And this is just a picture of her headstone. They made it so beautiful with her. This is her last school picture, and these was her favorite shoes that they put on here. She loved these shoes so much, she would wear these shoes till they almost didn't have no bottom on it. They was glittery, silver glittery, and she didn't care. She wore them outside every day. And then it says fashionista. Germani was 5 years old when she was shot. Germani, this is a picture of her 5th birthday cake. Dora, she loved it, Dora. This is her last Halloween in 2013. She carved her first pumpkin, and she was so proud of it. And she's like, you know, right here next to her pumpkin. And this is Halloween 2014. We're at her grave site. Placing pumpkins at her grave site because she can no longer carve pumpkins with us anymore. But that was one of her favorite things to do. And and this is Christmas. These are all pictures of her and her brother and her sister. She has a stepsister that she loves so much.
She described Germani as a joyful and fashion-loving little girl who adored dressing up, taking photos, and playing with her baby dolls. Germani's final Halloween was in 2013 when she carved her first pumpkin. A year later, instead of carving pumpkins with her, her family decorated her grave with them.
Describe how bad I feel. That family didn't deserve nothing. That little girl's not here because of me. My stupidity. I have kids of my own, so I don't know what that family's going through. I can't. I was stupid. I did not know anybody was in that truck. I mean, I shouldn't even have known better anyway. The reason why I had a gun is because I was almost carjacked 2 weeks before that. That's the only reason why I had it. I didn't have it to be tough. I had it for my protection. But I used it for the wrong reason. I wish I could take that family's pain and put it on my shoulders. I pray for that family every day. I look at that little girl's picture. I just can't believe that I took the life of a kid. I took a life, period, but of a little kid. That's not me. That's not what I do. They're right. I deserve everything you're going to give me and more. Nobody deserves what I put that family through. I hurt a lot of people, not just the mother, but you know the whole family and friends and just people that know them. People that don't even know him are just, it's a crime against a kid. I just don't want to, I mean, I can say I'm sorry, but it's not enough. I wish there was something I could do. I wish I could bring her back. If I could take my life and bring her back, I'd do it 100 times over. I just wish I could take their pain away. I wish I could take that night away. I wish I could go back to that night. But I can't. And I gotta live with that. The family's gotta live with it. I just wish there was something I could do. Because I'm not this monster that there people are making me out to be. It's not me. Yeah, I have my domestic disputes, but I don't go around shooting people. I don't brandish my gun. I mean, it's not. I'm sorry. I just wish there was something I can do.
You know, January 19th is certainly a tragic day for these victims. And your own mother and grandmother that are here, it's a tragic day for you and your family and those two. And they have to listen to you today. Count 3, you'll be sentenced to the Lorraine Correctional Institute for a period of 15 years to life. to be preceded by the 3-year specification, which will be served first and consecutive to the 15th to life, so that on that count you are effectively serving 18 to life. And for the reasons indicated, I do further sentence you on the count 5, the first felony, to 4 years to run consecutive to count 3, and in count 7, 4 years to run consecutive to count 5 and consecutive to count 3.
Gurkovich also stood in court, weeping, expressing regret for what he had done, but his apology could not undo the pain inflicted. The judge sentenced him to life in prison with eligibility for parole after 26 years. As of today, May 10th, 2025, Jeffrey Gurkovich remains in prison, serving a life sentence for the senseless killing of a young girl who had her whole life ahead of her. On a freezing night in late December 2022, Alexandra Eckersley, daughter of Baseball Hall of Famer Dennis Eckersley, gave birth unexpectedly in a wooded area of Manchester, New Hampshire. Living in a tent and unaware that she had been pregnant, she believed the boy had not survived. In a state of confusion and fear, she left the boy in the cold and called 911, initially providing incorrect information about the location.
On Christmas night 2022, the defendant, Alexandra Eckersley, intentionally led first responders away from the location where her newborn baby could be found. She left this newborn alone in a freezing tent for over an hour. Why? By her own admission, she did not want to get in trouble. The defendant was homeless and lived in a tent off a rail trail in Goffstown. The birth was unexpected, and she lost a lot of blood. Suffering from a medical emergency, the defendant and her boyfriend left the defendant's tent and walked to an area near the Westside Ice Arena where they could call for help. The defendant left the baby in the tent on the ground next to her bed. It was dark outside and it was freezing cold. Manchester first responders were dispatched to the area to assist the defendant. She reported that she did not know where the baby was. When fire and medical personnel arrived, they found the defendant at the intersection of the rail trail and the trestle bridge on Electric Avenue. She was alone. By this time, the defendant's boyfriend had left the area, so the defendant was now the only one speaking with first responders. One of the EMTs, Lauren Berry, treated the defendant, and as she was speaking with the EMT, the defendant directed the EMT and rescuers to an area behind the Westside Arena, close to where she said she gave birth. So from the trestle bridge, the ambulance drove to the parking lot behind the arena where a staging area was set up. They chose a spot based on what the defendant told them. As she treated the defendant, the EMT spoke with her about the birth. The defendant was evasive when asked where the baby was. The defendant told the EMT that she was walking along the trail when she felt like she needed to go to the bathroom. That time she went into the woods, and that is when she gave birth. However, the defendant did not give an exact location where within the woods. Shortly thereafter, the defendant agreed to show everyone the path that she walked. At this point, it was a little after midnight. It was dark and the temperatures were freezing, between 15 to 18 degrees. After exiting the ambulance, the defendant led the search party through a small path to the ball fields behind the arena. She walked them around one of the fields and then up through the main part of the trail. Once they reached the pavement, the defendant told the first responders that she walked into the woods but did not specify where. So based on this information provided by the defendant, the first responders entered the wooded area and searched for the baby. At around 12:50 a.m., Officer William Collins and Detective Joseph Attali from the Manchester Police Department arrived on scene to assist with the search. Officer Collins was assigned to speak with the defendant and gather information from her, while the other first responders continued to search for the baby. By this time, desperation was starting to set in because of the defendant's evasiveness. Going into this, Officer Collins believed that the team was searching for a dead baby based on the information the defendant provided to the dispatcher and the first responders. He and Detective Attali, along with other personnel, continued asking the defendant questions about the baby's location. The defendant maintained that the child was in the woods by the ice arena. However, nearly an hour after she gave birth, she told them a new fact for the first time. The baby was crying. The baby was crying when she gave birth. This completely changed the landscape of the search and increased everyone's urgency because now they were looking for a baby and not a corpse. By this time, the search had surpassed the 1 hour mark. Again, desperate to find the baby, the search continued in the woods. And at one point, the defendant advised the EMT and Officer Collins that she was bleeding. She was having another medical emergency. They returned to the ambulance so that the EMT could treat the defendant. Officer Collins and Lauren Berry were with her, along with Lauren's partner. The defendant received treatment and warming, but while she was doing that, the other first responders were still searching the woods. After about 10 minutes, Officer Collins asked the defendant if she could remember any new information. The defendant said no. And then she said that she could call them if she figured it out. Officer Collins told her that that's not how it worked. The EMT responded by explaining the severity of the situation and that they could just not leave the baby in the woods and forget about it. At that moment, now almost an hour after Officer Collins had arrived, and close to an hour and a half into the search, after she realized that no one was going to give up on finding this baby, the defendant completely changed her story and decided to finally tell him the truth. It's across the bridge. She admitted the baby was at her campsite on the Goffstown side of the bridge, completely opposite from where she told them it was. She said that she lied about it because she did not want to get in trouble.
First responders launched a search and eventually found the boy, alive but in distress due to the harsh weather. He was rushed to the hospital and treated for exposure. Thankfully, he recovered.
She obliged and showed him the tent that she slept in. He saw blankets covered in blood. He went through them looking for the baby. He then noticed a trail of blood running down the side of the bed, and he followed that trail to the floor. He found the baby. It was cold. It was blue. It was pale. It was covered in blood. It was covered in amniotic fluid. It was ineffectively breathing, but it was alive.
Here. Stop. Just wait. Here. Good. Ready? All right.
No, there's not her.
Oh, Jesus Christ. It's here. Yeah, it's here. It's still moving.
What?
It's still moving.
Oh, Jesus Christ, it's here. Yeah, it's still here. It's moving. After the child was found, the EMT sprung into action. She grabbed the child and called for a second ambulance to come to the scene. She raced off with the baby and ran back to the intersection. When the ambulance did not come, because time was now of the essence, the EMT hopped into the fire engine where they transported the child to the Catholic Medical Center. While en route, the EMT provided CPR and warming measures. And in that fire engine, for the first time, the child opened its eyes. At the hospital, the baby was transferred into the emergency department's care. Dr. Bridget Lennon and Nurse Alexandria Goslin took over the care. When the child arrived, the baby had an abnormally low body temperature and was hypothermic. And you will hear from both Dr. Lennon and Nurse Goslin. Nurse Goslin will describe her role in the baby's care and tell you about the baby's body temperature shortly after arrival. 82.5 degrees Fahrenheit. Far below any normal body temperature. Dr. Lennon will describe for you her role as the treating physician in the emergency department that night. She will tell you about the state of the baby's condition, that it had difficulty breathing, and confirm that it was hypothermic upon arrival. You will also hear from Dr. Lennon that she saw the baby open its eyes and that it had developed fingernails. She will tell you that while the baby was premature, the defendant was farther along in her pregnancy than she reported. In addition, both Dr. Lennon and Nurse Goslin will tell you that the baby was transferred to the Dartmouth-Hitchcock Clinic. When the baby was transferred to Dartmouth, its body temperature was still at 93.5 degrees and still in a hypothermic state.
Alexandra was arrested and charged with multiple offenses, including endangering the welfare of a boy, reckless conduct, and providing false information.
The defendant is charged with the following: reckless conduct, falsifying physical evidence, the welfare of a child, and 2 counts of second-degree assault.
She pleaded not guilty, and her legal team explained that she was struggling with both mental health and substance use issues at the time of the incident. During her July 2024 trial, Alexandra took the stand and expressed that she hadn't realized she was pregnant and believed she had lost the boy at birth. Mental health professionals testified on her behalf, explaining her condition during that time.
Stand, face the jury, and would the foreman please stand? Mr. Foreman, has the jury reached a verdict in this case?
Yes, we have.
And how say you, Mr. Foreperson, as to charge ID 2054609, charging the defendant Alexandra Eckersley with the crime of second-degree assault with respiratory distress? Do you find the defendant guilty or not guilty?
Not guilty.
You say, Mr. Foreman, that the verdict is not guilty. So say you all, ladies and gentlemen?
Yes.
Thank you. As to the next charge, charging the crime of second-degree assault for hypothermia, do you find the defendant guilty or not guilty, Mr. Foreman?
Not guilty.
You say, Mr. Foreman, that the verdict is not guilty. So say you all, ladies and gentlemen?
Yes.
Thank you. As to the third charge, which charges the defendant, Alexandra Eckersley, with the crime of reckless conduct, do you find the defendant guilty or not guilty, Mr. Foreman?
Guilty.
You say, Mr. Foreman, that the verdict on reckless conduct is guilty. So say you all, ladies and gentlemen?
Yes.
Thank you. And as to the charge ending in 614C, charging Alexandra Eckersley with the crime of falsifying physical evidence, do you find the defendant guilty or not guilty, Mr. Foreman?
Guilty.
You say, Mr. Foreman, that the verdict is guilty of falsifying physical evidence. So say you all, ladies and gentlemen?
Yes.
And finally, as to charge ending in 633C, which charges the defendant, Alexandra Eckersley, with the crime of endangering the welfare of child or incompetent, do you find the defendant guilty or not guilty, Mr. Foreman?
Guilty.
You say, Mr. Foreman, that the verdict on child endangering the welfare of a child is guilty. So say you all, ladies and gentlemen?
Yes.
Thank you.
In August 2024, a jury found her guilty of endangering the welfare of a boy, reckless conduct, and falsifying physical evidence, but acquitted her on more serious charges related to intentional harm. At her sentencing in October 2024, the judge acknowledged Alexandra's ongoing efforts toward rehabilitation. Judge Amy Messer sentenced Eckersley to 18 months in jail, though both sentences were suspended for 3 years. The suspension is contingent upon Eckersley's continued mental health and substance abuse treatment. By May 2025, Alexandra is reported to be living in Massachusetts with her mother and the boy. According to her legal team, she remains committed to rebuilding her life, and the boy is said to be doing well. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.